Well, hello, everybody. Good afternoon from Scotland. I think we're going to officially start. It starts with me, so if you're still joining, etc., the good parts will be coming shortly with Kirsten, so you have a bit of time. Yes, my name is Kay Tisdall. I'm here to welcome you to the Moray House School of Education and Sports Annual Lecture. First time that we're doing it virtually in this way. And the lecture is titled Making Children's Rights Real, the Opportunities of Incorporating the Convention on the Rights of the Child. Good, and indeed, if it's possible to move to the second slide, then it was just to emphasize a few logistics, just so that everybody is aware that we're recording the lecture. That's going to include the discussion following the presentations. We are quite a large group, which is really exciting, but it does mean that we suggest with the chat function that we use it primarily now for dealing with any technological problems. And later, if you have points to raise for the discussion or questions. And in terms of those, it would be useful to direct those to particular speakers and presenters. We are proposing not to use the raising of the hand function on Collaborate. It tends to be quite distracting, and as we may eventually grow to over 200, it could disrupt things. So if you can just resist using it if possible. So the next slide, if that's okay, Alice. I'm part of the Childhood and Youth Studies Research Group, soon to be morphing into the Children and Young People's Hub. And we're committed to making a transformative contribution to realizing children and young people's human rights by undertaking and promoting interdisciplinary research, teaching, policy, and practice. And as such, we're delighted to be one of the organizations supporting the formation of the Observatory of Children Human Rights Scotland. Other initiators are CELSIS, the Children and Young People's Commissioner Scotland, the Children's Parliament, Inspiring Children's Futures at the University of Strathclyde, the Scottish Youth Parliament, and together, the Scottish Alliance for Children's Rights. For all of those who use Tweet or other social media, you can see the hashtags on the PowerPoint, and the more we can take forward these discussions, the better. Many of you will have been with us actually in person at the observatory's launch at the end of February. As you can see, we had balloons, there were cupcakes, and there was so much energy, ideas, and support for the observatory. The vision of the observatory is that children's human rights are fully implemented in all areas of children and young people's lives in Scotland, in line with the UN Convention on the Rights of the Child and broader international human rights treaties. This will help to ensure that children's human dignity is respected and all children are supported to thrive and reach their full potential. If you've looked at the observatory's leaflet, you may have noticed the statement, "We want to change locally and learn globally." And that's exactly why the observatory wanted to work with Moray House for this annual lecture and to have Professor Kirsten Sandberg join us from all her international experience in children's human rights. At this time in Scotland where we're poised to make a big step forward in terms of incorporating the UNCRC into our domestic law. So I'm chairing our session today. I trust you will have seen the agenda and the biography sent out in advance. To let you know that the Minister for Children and Young People, Ms. Mairi Todd, had very much wanted to attend. But there's been a clash with parliamentary business. The Children's Scotland Bill is being considered almost as we speak for Parliament. And I know many of you, like us, have been working in terms of ensuring the Children's Scotland Bill is compliant with children's rights, indeed supporting Yellow, our young expert group, through the Improving Justice and Child Contact Project to really influence the legislation. So I guess it's a particularly good reason that Mairi Todd is there and working on the legislation. So we really appreciate that Mairi Macpherson from the Scottish Government has graciously agreed to make the government's contribution. Mairi has been very much in children's rights and developing policy. She's currently the Deputy Director for Creating Positive Futures at the Scottish Government, and we'll be hearing from her later. So with these initial remarks, let me hand you over to Richard Andrews, Head of Moray House School of Education and Sport at the University of Edinburgh, for a particular welcome. Over to you, Richard.
Thank you very much indeed, Kay. And can I just start by thanking you and your team for putting on such a splendid lecture this afternoon in trying circumstances. So congratulations to you all from the beginning. And a warm welcome to everyone, to Moray House, as Kay has said, and to the University of Edinburgh. Since I arrived back in October, which seems a very long time ago now, I've been so impressed by the vibrancy of the school's research on children's human rights, on childhood and youth studies, on the early years, on the activism of youth. And within the thematic hub on children and young people that Kay referred to, we draw not only on the wonderful expertise of Kay and her immediate team, but on international comparators and partners. We have specific projects on ending violence against children, a lot of work on early years, and other aspects of this field. It all chimes with our values as a university and a school, which include inclusion, a strong commitment to education for social justice, and accessibility for all. We link in an interdisciplinary way right across the university. There are fantastic resources we draw on in social sciences, arts, and indeed in the sciences. But we also link beyond the university with children, with parents, with practitioners, and policymakers. And I think the new Observatory of Children's Human Rights, Scotland, launched in February, is a great example of the collaboration that's gone on in Scotland with ourselves, government, and other universities to put Scotland centre stage with regard to children's rights. So without going on for too long, I just want to give and repeat the very warm welcome to the Deputy Director for Creative Positive Futures in Scotland, Mairi Macpherson, and Bruce Adamson, who's with us today, the Commissioner for Children and Young People in Scotland. But finally, I want to welcome Professor Kirsten Sandberg from the University of Oslo. Kirsten, it's wonderful to have you with us this afternoon. I'm a great fan of Oslo and of Norway in general. I've visited several times, and it's wonderful to have your presence and perspective this afternoon giving the Moray House Annual Lecture. So I'll now hand back to Kay. Thank you, Kay, to introduce you, Kirsten, and we look forward, as we all will, to your lecture and the responses this afternoon. Thank you, everyone, for coming.
Richard, thank you for such a gracious welcome. And indeed, to go on with the agenda, I now have the really welcome task of introducing Professor Sandberg, who will shortly provide our annual lecture. I first met Kirsten as a professor of law at the University of Oslo, as we had a common interest in children and young people's participation in family law. Kirsten's always been a leader in children's human rights, and amongst her many contributions, she was elected to the United Nations Committee on the Rights of the Child, which is the body of experts who monitor the UN Convention and the 3 optional protocols and much more besides. This international experience combines with her particular knowledge of Norway, which has gone far in terms of incorporating the CRC domestically, making her ideal to contribute to us learning globally so we can change locally. Because we're poised here in Scotland for direct incorporation of the UN Convention into domestic law, I've now worked in Scotland for over 20 years, and there's been ever increasing support for children's human rights. But at times we do risk sometimes being stronger on the rhetoric than the reality. But now we have this opportunity to ensure the UNCRC is squarely in our domestic law, something that we as duty bearers are accountable for, and where children can really expect to have their rights recognized, supported, and promoted. So indeed, to make rights real. So we really look forward to what Kirsten has to say. Over to you, Kirsten.
Thank you so much for this warm welcome, and also thank you very much for inviting me to hold this lecture at this important event of the Moray House. It's a pleasure for me to be here with you in Edinburgh today, though I would definitely have loved to be there in person instead of doing it digitally. But this is the way we have to do it now. So what I'm going to talk about mainly is from the point of view both of the Committee on the Rights of the Child, and also mainly from the point of view of Norway when it comes to incorporating the convention. I wonder, when I change the slide, does it change for you as well? Oh, I can't see anybody.
I'll answer it. Yes, it changes for me, Kirsten.
That's good, thank you. So this is the front page of my own lecture. This is the overview of what I'm going to speak about. So the first issue is, what do the CRC and the UN Committee say about incorporation? Then some words about the process in Norway of incorporating the convention. One point about legal opportunities and challenges, and also the interpretation. This is partly from the general point of view, but also from the point of view of Norway. Awareness, the awareness of children's rights, how this has been in Norway before and after the incorporation. Then a few words about prevention, remedy, and redress for violations or breaches of children's rights. Then I was asked the question whether it has led to a culture change in Norway with regard to viewing children or children's rights. So I'll try to answer that. And I've also been asked if there's a need for, if I can see that there is a need for additional legal measures in Norway to make it even better implemented. And then finally a conclusion. So what do the convention itself and also the UN committee say about incorporation? Article 4 of the CRC, the Convention on the Rights of the Child, says that states parties shall undertake all appropriate legislative, administrative, and other measures for the implementation of the rights recognized in the present convention. So there is an obligation, a clear obligation, to undertake all legislative measures to implement the rights. And then this is further specified in the committee's general comment number 5 on general measures of implementation of the convention, where already in paragraph 1, the general comment says that states have the obligation to ensure that the convention's principles and provisions can be directly applied and appropriately enforced. This is a fundamental obligation of the states. And then in paragraph 20, the general comment says that the committee welcomes the incorporation of the convention into domestic law. And it also says further on that incorporation should mean that the provisions of the convention can be directly invoked before the courts and applied by national authorities, and that the convention will prevail where there's a conflict with domestic legislation or common practice. This is from the same general comment. So the words are quite strong. The message is quite strong from the UN Committee on the Rights of the Child, that states should actually incorporate the convention, or at least make it as close to incorporation as possible. But I would say incorporation, full and direct incorporation, is actually what is recommended by the committee in general. And then let's look at what the committee said to the UK a few years ago in 2016. Under the heading of legislation, the committee recommended that the state party, meaning the UK, should expedite bringing in line with the convention its domestic legislation at the national and devolved levels and in the overseas territories and the crown dependencies, in order to ensure that the principles and provisions of the convention are directly applicable and justiciable under domestic law. And I'll say a bit more about what this means legally and domestically, but I'll come back to that after having said a little about the process in Norway concerning incorporation. We got our Human Rights Act in 1999, and in that act, the 3 so-called central conventions were incorporated, not the special ones. The three central conventions, they're considered to be the two UN covenants on civil and political rights and on economic, social and cultural rights, plus the European Court of Convention of Human Rights. And the CRC was considered to be a special convention. Then the Parliament said that, well, the CRC is not that special, and asked the government to come back with a proposal to incorporate the CRC. They also mentioned that actually the CRC is a very broad convention. It is not special in its contents. There was a working group of various ministries that was established, and in 2001, that working group proposed a partial transformation, and that was also the recommendation of the Ministry of Justice when it sent this proposal out for a written hearing. But after the written hearing, the Ministry of Justice actually changed its mind, and in the bill of 2003 instead proposed that the convention should be incorporated in full. And that must have been because of some quite strong voices, I think, from the bodies that had expressed their opinions in this hearing. And one of them was the association, or the Norwegian Association of Judges. And they really had strong arguments in favor of incorporating the convention. They said that they were used to vague provisions, insofar as you could say that they are vague, these provisions. And they also said that this would send a much stronger signal to the legal establishment or whatever, and also to others that they should actually incorporate the convention, or I mean that the convention is actually to be taken seriously. So they did say that the Ministry of Justice, when they changed their mind, they did say that the UNCRC is in a particular position. Children are a vulnerable group, a disadvantaged or marginalized and vulnerable group that has a need for an extra strong protection. And then they wanted to send a signal to the whole society about that by incorporating. So it was then incorporated in its entirety in 2003, and also in the same way as the other conventions that have been incorporated through the Human Rights Act, it was given priority over other legislation in case of conflict. So if there is a conflict between other legislation and the Convention on the Rights of the Child, the Convention on the Rights of the Child should prevail, which is really useful when it comes to interpretation and when it comes to actually giving the strength to the convention that it needs. So it was incorporated in the Human Rights Act at the same level with these other sort of central conventions. So it was in a way acknowledged that the CRC is also a central convention. It's just for a smaller group, but it's not a small group. It's really a big group of all persons up to the age of 18. And in addition to that, in 2014, the 4 general principles of the convention, that is non-discrimination, best interests, the right to life and development, and the right to be heard. Those 4 general principles, plus the right to dignity and integrity of children, were included in the constitution, in the Norwegian constitution in 2014, when we had our bicentennial of the constitution. They included a whole chapter on human rights. And there was a discussion of whether we should actually include a separate article on children's rights, but luckily, or fortunately, that was done in the end. We are very happy about that too. So what are the legal of incorporation of the CRC? It definitely gives it a stronger position in the domestic legal system than when it is not incorporated. Well, I should say that Norway is a dualist country, and that's why we need to incorporate it or make it into national legislation somehow in order to have it count as proper Norwegian legislation and not just a kind of legal argument. We could use it as a source of law before too, but it was not strong at all, only a kind of argument or a weaker kind of argument. So the stronger position is through the rights of the child being presented holistically. You use the whole convention. You don't only see fragments of the convention included into various pieces of legislation. In Norway, we did that as well, because the authorities found, and I agree with that, that it's necessary also to put specific parts of the convention into those acts or statutes that professionals use in their daily activity, because otherwise they may overlook it, or they may think that it's too difficult to look into the CRC. So it's quite useful to have some of the provisions into some other pieces of legislation. But in addition to that, it's really, really useful to have the whole convention holistically presented in Norwegian law, so that we can use it both in its entirety and read all the provisions in context, but also so that the text of the convention can be used directly in cases. We don't need to go via other pieces of legislation where the legislator may actually also have modified the rights of the convention to make it suit the normal way of writing Norwegian acts, or maybe to suit their own purposes. So that's the next point, that it's the most loyal way to make the CRC domestic law, to incorporate it, because you don't then modify the children's rights by the legislator. You can use them directly, which also makes it easier to hold the government to account, because you can go to the text of the convention and say that, look, this is what you actually have to do. Also internally in the country, not just that you are to be accountable to international bodies. In Norway, I don't know how that would be in Scotland, but local authorities were not directly bound by the convention before it became incorporated. So that was also an important effect of incorporation, was to make it obligatory also for the municipalities to follow, and the counties to follow the convention and to apply it always. So to say a little about the legal opportunities or the benefits of incorporation seen from the international level. It's really, really a great benefit that states use the same text, a great advantage for the international society, both the legal society and all of the international society as well, that all the countries actually in their own domestic law, they use the same text of the convention, that is not transformed into all sorts of different provisions. And also it's been, or it is very significant that interpretive documents that are made at the international level are relevant to the interpretation directly. So it means that it is supposed to be interpreted dynamically, which has been said by the UN committee, and which is already being done by the committee and others that use it in their own countries. But it's good when it's interpreted, or it's important when it is interpreted dynamically, meaning that it changes its contents over time, because the circumstances change, and we know much more about children's development, for instance, than we did 30 years ago. So, but then the UN committee may lead the way. So we have one body that tells us how this interpretation should be developed. You don't all interpret it in all sorts of different directions in our own countries. So to the challenges, that there was a fear in Norway of increased litigation, that the incorporation would lead to more cases before the courts. Actually, I'll come back to that. Then there was a case there was a fear that the CRC would be too vague and aspirational, and I'll comment directly on that, because this was a very strong argument by the Attorney General in Norway, saying that he feared that there would be too much power to the courts by incorporating it. And this is a myth, I'd say, because there are many of the provisions in the CRC that contain clear obligations. And if some of them are vague, well, that is the case with many pieces of legislation or provisions in Norwegian law too. So this is not very different from what the courts have to tackle anyway. Then the budgetary implications, I'll come back to that, because that was another argument, that it would interfere with the sovereignty of Parliament. So did it lead to increased litigation? Well, what we see is that the CRC is increasingly used in litigation, but mainly it's used in cases where those cases would have been brought anyway. When I look through Supreme Court practice or Supreme Court jurisprudence, the CRC is mainly used in child protection cases, in immigration cases, and in parental conflicts. And those cases would have been brought by the parents anyway. It seems this has not been really counted as far as I've been able to see, but it seems that incorporation has not led to more cases. This is from when I look at all the jurisprudence we haven't seen a rise in the number of cases dealing with the CRC or dealing with children or children's rights. And if these vague and aspirational provisions are used in litigation, it's as an additional argument. Cases are not raised or not brought before the courts, filed before the courts, only on those vague and aspirational provisions. It may be used, for instance, the right to health may be used as an additional argument when there's a dispute over the right to health under the Norwegian legislation that is on health. But then it is not a case which would be brought only under the CRC. So there are no budgetary implications of justiciability so far. Another matter is one could actually wish for more cases to be brought to the courts, because that would be part of the benefit of having the CRC incorporated, many would say. But in Norway, children and young people up to the age of 18, they don't have legal status in the way that they can actually bring their own cases to courts. They need to be represented by adults. So that might be one of the reasons why there haven't been a rise in the number of cases. But also courts are not child friendly. I think this is true for so many countries. So I would say that the proper complaints mechanism would be useful for children, so that they wouldn't have to go to court with their if they claim that their rights have been violated. But we don't have a good complaints mechanism in Norway. We do have it for certain parts of the legal system, for instance, in education, but it's not well known by children. Not easy to use, I would say. So how is the CRC interpreted by the courts in Norway? I would say that is varying. Some courts are quite bold in their interpretations and go quite far in giving children rights or increasing their rights maybe. Some courts are more cautious in their interpretation. And the Supreme Court has gone both ways, I would say. In immigration cases where there are, of course, strong opposing arguments in those cases. The immigration regulation argument is always there, and at least in Norway, pretty strong. And in those cases, the majority of the court, the Supreme Court, has been quite cautious, but there have been strong dissenting opinions. For instance, when it comes to the right of the child to be heard, even when the child is only just below 6 years. For child protection cases, it seems they have a more child rights friendly attitude in the Supreme Court, even though there are also the strong opposing rights of the parents on the other side, but they seem to be more willing to promote children's rights in those cases. I would say when it comes to what provisions are used, it's the general principles, the 4 general principles that are applied most frequently by the courts. Mainly, I would say the best interests principle, or the right of the child to have his or her best interests taken as a primary consideration, and also the right to be heard, the right of the child to state his or her views. They are applied most frequently. So you could wish for other provisions to be used more, I think. However, for children in conflict with the law, Article 37 and 40 are used quite a bit. general comments of the Committee on the Rights of the Child. There's been an extensive discussion in Norway about the use of those general comments and their value as an interpretive argument or a source of law when it comes to interpreting the CRC. But finally, just before Easter, I'm glad to say, the Supreme Court said that they have been given great weight by the Supreme Court. So I think I hope this is the final word, that they will actually be given great weight also in the future, because I think they deserve to be. It is the best or the only international interpretation that exists on the convention. That is the general comments of the CRC committee, which is the one which has been appointed by the convention to actually oversee or monitor the implementation of the convention in all countries. So has the incorporation of the CRC led to an increased awareness and understanding of children's rights in Norway? And I would say definitely yes. When it comes to lawyers, they were not very interested in the Convention on the Rights of the Child until it was incorporated. But after that point in time, there was a rise in the requests for training and questions about how should we use this convention, and practicing lawyers often are quite inventive, and they use whatever is there of sources of law, and they were quite good at promoting the CRC before the courts, I think, and started using it. For the municipalities, this was the first time the ministry actually made a guidance as to how they should apply or use the CRC. For children and the public, there's been much more awareness since incorporation. So both children and the general public has been much more aware of the convention. Not to say that everybody knows well what it's about, but they know about the convention and they know that children have rights. And children are learning more and more, I think, in school. Professionals working for and with children, we really have a job to do still, but it started, I would say, in 2003 when it was incorporated. In the child protection system for social workers, child protection workers, the knowledge and training on how to use the convention has gradually increased, but it was as late as, I think, 2008 or 09 that somebody pointed out that, well, child protection workers are not good at talking to children. So it started not immediately, I'd say, after it was incorporated. Some years had to pass before people really became aware that this was something that should be used. But if it hadn't been incorporated, it wouldn't have started, I'm sure. In immigration, there is a strong awareness of the convention. It was actually in the law even before the incorporation. But in practice, they still have a long way to go. But they do trainings. There's a lot of awareness from authorities, but they have a difficult task, I guess. Teachers help. Oops! I suddenly get my voice back to myself, but now it's okay. So for teachers, healthcare workers, and the police, to mention some other professionals that also work with and for children, I would say it is coming a bit more slowly than in the child protection system and the immigration system. More training is needed, but they've also been coming up in the last few years. There is a program run by the county governors, which is called the Giant Leap, which has been really, really important for the implementation at the local and county level in Norway. I cannot say a lot more about that, but they have made a plan for municipalities on how they can actually report to themselves and to the county on how they apply the convention, how they use it. So, has the incorporation led to more prevention of breaches of children's rights or violations? I've just mentioned here a few examples. As for prevention of violence, I would say definitely yes. In the upbringing and at school, that incorporation has really contributed to prevention of that kind of violations, because we see that having something in the law is really important, and we don't have it only in the CRC incorporated, but it has been an important trigger for having it also properly prohibited in other parts of the legislation. In relation to deaths of children by violence in the home, the obligation to report has been discussed with a child rights approach, just to mention one thing. And well, the rights of children is always raised in that context. Including children's views in various cases has been really done a lot more lately, for instance, in child protection. As for issues in the Corona period, I've just mentioned a few examples, but I just saw that in Scotland, quite a lot has been done actually by the government to follow up on the recommendations of the Committee on the Rights of the Child. I haven't seen this done in Norway. So this is more the issues that have been discussed by people who are interested in children's rights, and not least by the ombudsperson. So it's the right to education when during homeschooling, but also after, because they don't go. I mean, not all children go to school every day and all together. So there's still a big discussion on this. The right to assistance for children with a difficult care situation has really been raised for good reason, because children have been left alone with their maybe not so kind or caring parents, those that would have gone to school every day and might have been picked up by the protection system. It's been a difficult situation. The children's ombudsperson really uses the CRC a lot after it's been incorporated. They did it before too, but now they can do it with a much greater strength. So has it led to remedy and redress for violations or breaches of children's rights? Well, cases on, for instance, compensation for insufficient schooling or inadequate action from child protection authorities are argued with a child rights approach. I'm uncertain, because there hasn't been any research done, as far as I know, as to whether incorporation has actually led to remedy and redress in more cases. I think a single or a unified child-friendly complaints mechanism would probably help for children in Norway to more easily raise claims for remedy and redress for violations, so that they wouldn't have to go to court, which is difficult, as I said. So has there been a culture change in how children are viewed? Yes, I would say so. Children are seen as subjects of rights after the incorporation, not just as an object of concern or somebody that we should be kind to. The best interest of the child are on everybody's lips, but I still say we have a way to go in practice. When it comes to children's right to participation, or to state their views and have them heard in individual decisions, there's definitely been a growing awareness over many years of children as actors in their own lives. And I think everybody that makes decisions for children in that kind of cases, they are well aware of this obligation. When it comes to children as agents of change in general policy making, it's coming, I would say, but we are not there quite yet. It's more, I mean, they are heard to quite an extent, but the issue is how much are they actually listened to and how much weight do their views get. So what additional legal measures could be useful or could support a better implementation in Norway? I think we could do more when it comes to including the contents of relevant rights into sectoral legislation. It was done to a certain extent when, it was done as much as the government thought was enough when the convention was incorporated, as I mentioned. But it's mostly in those laws that have child in the name. There has been a proposal that best interest should be included into all relevant legislation, and then relevant in a wide sense, with some criteria specified. And I think that would be a good idea, actually. It would make all those professionals, all those sectors more aware that they actually have to make a best interests assessment. Children's participation, I think a useful additional criteria or requirement in the law would be for authorities to give feedback to the child or children when children have been hurt. This is something that would probably raise their eagerness to hear children and also to give weight to what they say than when they would have to explain what they had done with children's views after they heard them. And there should be better solutions for including children's views in policy-making processes. Sorry. So for the conclusion, this is my final picture. I would say all in all that full and direct incorporation has been a success in Norway. Very few of those critical voices that were there before the incorporations have been heard again, or at least those arguments have not been repeated to any extent that I've been aware of. And this is what I hear also from my colleagues. There hasn't been a lot of skepticism or criticism after the convention actually was incorporated. The CRC has a strong position in the law, which is really useful. The awareness before in the public and by professionals and also by children themselves before the incorporation and after the incorporation can hardly be compared, because it's been so much greater after the incorporation. Training of professionals started gradually after the incorporation and is still ongoing and has to be ongoing. Central authorities became more committed, it seemed, after it was incorporated, included when it comes to including children's views, or including children's rights in legislative processes. And the change in culture, I just mentioned, the child is viewed as a rights holder or a subject of rights, which is really important, that things or matters or issues have to be seen from the child perspective. And through a child rights approach. Thank you.
And thank you to Kirsten. It's Kay Tisdall here again. As we hoped, Kirsten, it has been so useful to hear from somebody who not only knows about this critical issue cross-nationally, but also coming from a country where this is such a recent and ongoing issue. So it's been so important for us to learn from you. And I'd particularly note how helpful I found it that you really directly looked at what were the concerns and the criticisms, and then shared with us again very directly what the experiences have been from Norway, as well as your international experience. So thank you. I'm sure it's going to generate a lot of discussion. Just before we get to that, might I move to inviting Mairi Macpherson to give us a contribution from the perspective of the Scottish Government. Mairi, as I said, is joining us as the Deputy Director for Creating Positive Futures at the Scottish Government. You haven't been able to see her biography before today. It is amazing and impressive. Mairi, I think we first met when you were working in the Standards in Scotland Schools Act, which was one of the first acts of the Scottish Parliament and brought in key aspects of the UNCRC, which were quite extraordinary to see in law at the time. Since then, she's held a range of posts in the government, from looking at police and fire reform to Healthcare Improvement Scotland, for example. Since joining Children and Families in the government, Mairi has led work to building Getting It Right for Every Child, to taking forward the participation legacy of the Year of Young People, and very importantly for us, delivering on the commitment of Scottish ministers to incorporate the UNCRC into Scottish law. So with that, I'll invite Mairi to give her a 10-minute contribution.
Thanks. Okay. Well, I just want to add to your thanks for Professor Kirsten Sandberg. I found that a fascinating insight into the Norwegian experience, and so timely and helpful for us to hear, given where we are with incorporation in Scotland. So much in there which I will no doubt be reflecting on as I listen to the recording again. Lots for us to learn from. Thanks to Kay for the really kind introduction. I'm really delighted to be here, but I do pass on the regret from the Minister for Children and Young People, who really wanted to be here, but is, as Kay said, required of Parliament today. I'm really pleased to see how many attendees we have. That is so encouraging to see the number of people who are interested in learning more about the experience of incorporation and the lessons we could learn for Scotland and indeed elsewhere. And I'm noting that a number of members of the audience are joining us from other countries. So with that in mind, I want to just very briefly cover 4 elements. I want to very briefly touch on the unique context we have in Scotland, and therefore the unique challenges that we will be grappling with in order to incorporate the UNC. And I'll say a little bit about our journey so far to make children's rights real in Scotland. I will give a little bit more on the progress and where we've got to so far on our journey to incorporate. A few reflections on the current context and what the coronavirus health emergency has meant for children's rights. And I'll briefly say a little bit about next steps. So, conscious of time, I will dive in. But I thought I couldn't skip over a little bit about the Scottish context. This is really pretty unique. As most of you will know, we have a Scottish Parliament. Actually, the Parliament first is known to have convened in 1235, but its current iteration first sat on the 12th of May in 1999. So we had a significant gap of over 290 years between one Parliament and the next. But in the interim period, we saw the maintenance of a distinct legal system in Scotland, as well as a separate education system and separate church. When the Scottish Parliament was reconvened following the passage of the Scotland Act, we note that the Parliament to itself a number of powers, including education, health, justice, and many powers related to planning, among other things. And of course, the powers of our Parliament have since been extended by 2 further Scotland Acts in 2012 and 2016. So we now have certain aspects of taxation and social security, for example, which are within the competence of the Scottish Parliament. However, it's important to note that the UK Parliament retains powers in relation to defence, immigration, most aspects of social security and taxation, and international relations. So for the purposes of incorporation, the state party is the UK, not Scotland, and not all aspects of UNCRC lie within devolved competence. As Kay touched on, beyond the Parliament, there is an important Scottish context to reflect on in terms of children's rights. We have had over a decade of our Getting It Right for Every Child approach, which is a rights-based approach of multi-agency working with the child and the family at the heart. In 2014, we passed legislation, the Children and Young People Act, which put the UNCRC into our domestic law in Scotland for the first time. And it did give ministers some power to take steps to better or further meet requirements of the UNCRC, and it placed a reporting and planning duty on them. And some folk who are here as part of the lecture will know that the first action plan and report were published back in 2018. This piece of legislation also placed a reporting requirement on public authorities on their activity to meet the requirements of the UNCRC, and the first reports were due on the 1st of April this year. But our global public health emergency has introduced some delay into the reporting under that legislation. Many folk on the call will recall that 2018 was also the year of young people, a themed area of activity putting young people at the centre and in the driving seat. It's worth mentioning that just before lockdown, we saw our 4th annual cabinet meeting with children and young people in Scotland in March. That involves representatives of the Scottish Youth Parliament and the Children's Parliament, and a report is published each year on progress against the actions agreed with the children and young people who attend. So we have, as Kay indicated, been doing a number of things to make children's rights real in Scotland over a number of years. But it's important for us to note some of the key points on our timeline towards incorporation. So as many of you will know, in April 2019, the First Minister committed to incorporate the UNCRC this Parliament. And that means by May next year, which will be when the next parliamentary elections are due to take place. So in the summer last year, the Scottish Government launched a 3-month consultation on options or models for incorporation. In June 2019, we convened a working group of experts, of academics, of representatives from a range of public bodies, a range of legal practitioners and legal representative bodies. And in November, the Deputy First Minister, John Swinney, made a statement in Parliament on the 30th anniversary of the UNCRC and published the outcome of our consultation. And as part of his statement, he made a commitment on behalf of the Scottish Government to incorporate in full and directly, using the language of the Convention as far as possible within the limits of the power of the Parliament. So ministers have made a very clear choice about the method for incorporation in Scotland. I mentioned that we set up a UNCRC working group. This group has met 8 times and is in the process of finalising its report to a broad-ranging group with representatives of prospective duty holders. I forgot to mention parenting organisations, a number of children's rights stakeholders and organisations, as well as the Scottish Youth Parliament and others. The deliberations of the group have informed the development of policy, which has been moving at pace to meet ministers' ambitions for incorporation in this current session. And we have a commitment to introduce legislation within year 5 of the Parliament, which is the 5th year of the parliamentary cycle, and it begins after the summer recess this year. I wanted to just pause while talking about incorporation to reflect really on some of the new challenges that we face in the current context. The emergence of a global pandemic is the backdrop to all of our work currently, and unprecedented is a word that is overused, but it is accurate. The UN Committee identified 11 recommendations for areas that all countries should focus on in considering children's rights in responding to the pandemic. And we in government have been using those as a very helpful frame for the action which we're taking forward to address some of the challenges at this time. It's worth saying that probably in common with most organisations, we have new resourcing challenges. Of course, many of my colleagues who work in children and families have their own children and families and are now balancing work with caring and supporting home learning. And as you might expect, government was required to be nimble, and so some of our staff have been redeployed to immediate COVID-19 response roles. So a number of challenges. We're also very aware that our stakeholders, those public authorities who will be subject to duties under the legislation, are under enormous pressure at the moment. The capacity of those stakeholders to engage with us, to consider UNCRC and its impact has been affected. However, and I suppose I'll just wrap up with a few words about next steps, and really some words of assurance that in the midst of this and these challenges and barriers, there is a clear and continuing commitment to children's rights. We conducted child rights and wellbeing impact assessments for both of the emergency bills which have gone through the Scottish COVID-19. We recognise that those assessments were done at pace, and there may be many things which a number of commentators and stakeholders have pointed out that could be improved. And indeed, we really welcome the Scottish Observatory on Child Human Rights doing work now to carry out its own independent child rights impact assessment. Our focus on children's rights in this current context is particularly acute in relation to those who are most vulnerable. And some colleagues on the call will be aware of the creation of a COVID-19 Children and Families Leadership Group, along with partners in local government. And alongside that, an initiative to bring together groups, individuals and mechanisms to ensure that the voice of children and people is heard in that process, and that we are responding to and working with children and young people as we respond to the challenges of COVID-19. And in the midst of all of this, there is an unwavering continuing commitment to deliver the UNCRC bill in this current session. And this is despite the need to deliver on urgent priorities on COVID-19. We are refocusing our resources to make sure that this happens. And Alice has sent me a very polite prompt, and I will wrap up here and allow some time for questions. Thanks, everyone.
And thank you so much, Mairi. Thank you, everybody. Mairi, you dealing with the technology, and the group listening. I think we were able to get the clear messages that you gave and really welcomed the update and where we are in Scotland and from the Scottish Government. So thank you very much. So yes, now we're going to have about 15 minutes, a chance for some discussion that you can pose things to our speakers, etc. Just looking at the slide, a few things. The plan is that you are most welcome to put your point for discussion or question up in chat. Helpful if you direct it to a particular speaker, if you would like to. We'll be looking through the chat and trying really to get through as many points as we can within that. We would love to hear from people directly, but I think with the technology, we'll not ask you to raise your hand nor to speak because we'll get through it through the chat. You may have gathered it's a little bit of a race because I think our time will be up soon. So please just get typing and we'll try and get as many as we can. So available to respond. Kirsten and Mairi have offered to do so, and we also have Bruce Adamson, who will be finishing up our lecture. But Bruce is also here for discussion. He is the Commissioner for Children and Young People in Scotland. So I think with that, if all our speakers and presenters are ready to respond, Nancy got the question in first, and I believe this will be directed to you, Kirsten. Has there been any specific instruction or guidance regarding who determines the best interests of the child and how? If I can move over to Kirsten to respond.
No, there hasn't been any specific guidance given by the authorities or by the government on that point. Well, there is some guidance in some legislation. So, for instance, in the Child and Parents Act, which is mainly on parental conflicts and so on, there is some guidance as to what to look into, and I think, or the elements of the best interest, and I think that's quite useful. We also use the CRC General Comment number 14 quite a bit on best interests, but there isn't any. I think it would be difficult actually to make an overall guidance on this. Outside of what we already have in General Comment number 14, but it's useful to do it for several pieces of legislation, and it hasn't been done. But of course, the courts do it when they get cases on child protection and on family issues.
Kirsten, thank you so much for that. We'll give you a little bit of a break because, Mairi, I think the next comment question is directed towards you in the first instance. Bruce may want to come in as well. But as you can see in the chat, David asked that the UN Convention on the Rights of a Person with Disabilities raised 4 concerns, or I guess that would be the committee, about the UK's approach to the right to inclusive education. And then he comments, in 2019, the Scottish Parliament voted to regard moves to inclusive education as only having laudable intentions. Given such concerns, will the UNCRC incorporation be partial and not full and direct for children with disabilities? Mairi, as much as you're able to respond, would you like to say something on that?
So I think it's probably worth saying, and I didn't cover this in my main presentation, that we're very aware that ministers' ambitions extend beyond the UNCRC, and they're very interested in a number of other international human rights treaties and working towards creating a framework for human rights in Scotland which goes beyond, far beyond the UNCRC. And work is underway through the Human Rights Task Force to bring forward further legislation to make that happen. So we in children's rights are somewhat ahead of that, and the commitment is to incorporate the UNCRC in full. So that includes all the articles possible within the powers of the Scottish Parliament. So I would expect all relevant provisions in relation to UNCRC provisions to be included in the legislation, but it doesn't extend to other treaties which will be considered in a further tranche after the elections in May. So that's the intention of ministers at this time.
Mairi, thank you for that clarification. And Bruce, would you like to come in? I know the Commissioner's Office has really prioritized the issues for children with disabilities, so you may have a comment to make.
Yes, I think it's a very good question. We need to be clear that the Convention on the Rights of the Child contains specific obligations on the state in relation to disabled children and also in relation to education. So the CRC provides a very useful framework for this, but the Convention on the Rights of Persons with Disability does go further in some aspects. And so it's important that we build on the CRC, which will be full and direct incorporation, that commitment from the government, which will be really important in protecting the human rights of children and young people, particularly in relation to the inclusive education that you ask about, David. But as Mairi says, that'll be further supplemented by additional work. That other work's a bit more long-term, so our very clear focus needs to be on getting full and direct incorporation within the next few months, within the next year, and then relying on the rights commitments and rights obligations in relation to disabled children, and particularly around education.
Bruce, thank you so much for that. Next, move to Jennifer Davidson's point, which is directed to yourself, Kirsten. As you can read, Jennifer says, thanks so much for such an important perspective, especially for us in Scotland at this time. Can you say a bit more about why you think the impact of the CRC has been slower amongst child protection police and schools in Norway? Over to Kirsten.
Thank you. So did you say child protection? I didn't hear the last part.
Yeah, sorry, child protection, police and schools. So yes, the areas you thought were a bit slower in Norway.
Yeah, I see. Yeah. Well, actually, child protection has been quicker than schools and police, and that's because I guess everybody that is both inside the child protection system, but also lawyers and so on that deal with these cases, they are very much onto legal thinking and rights thinking. So it has been quicker, but it was still slower than we could have wished for. So maybe the premises for the questions were not quite right, that I was a bit unclear about that. But still, why they didn't start having children's views included until, let's say, 2008 or 9, that's really hard to say. I think now my voice is coming back to me. I don't know why that happens. Anyway, I think, oh, it's share video. Sorry, you don't see me.
Yeah, I think it's okay, Mairi. It might just be because your microphone's still on. We might have to turn it off when Kirsten's speaking. Sorry about that. Kirsten, you want to try again?
Yeah, I'll try again. So the child protection system has been quicker to pick it up than the schools and the police, actually. But why it took some time before it started happening? I think it needed some time, actually, and maybe the people around the child protection system, or those that were in charge at the central level, were not quite as on the ball that you could have wished them to be. I don't really know, actually.
Well, the researcher, Kay here, and me is interested to find out why. Kirsten, if you stay there, there's a lot of questions for you. So let's see where we can get to. So one from Kathy from the Children's Parliament. How much do you think the pre-existing culture around children in Norway influence the successful incorporation and growing implementation?
Well, I think that has been important. I guess it has, but I think, for instance, when I mentioned the Norwegian Lawyers Association, I'm not sure that they are so much influenced by the general attitude to children. I think they saw it more from the legal point of view, and actually found out that it wouldn't be such a big problem for their carrying out of their work. So I think partly it has meant quite a lot for many of the other bodies that made their voices heard. But I think also there are other reasons. Thank you.
Thank you again. Just to give you a moment of break, just you may see next in the chat, there's a comment from Finland, and here they say their immigration authorities have over 100 pages of guidance on how to assess the best interests of the child. That seems rather a lot, but we would love to hear more about that at some time. Next is Tara, who I know is contacting us from Canada. She says thanks to both speakers, and the question is for both. So in a moment, I'll invite Mairi perhaps to respond. What are the most important elements to advance the campaigns for CRC incorporation in Norway and Scotland that can serve as useful lessons for other countries? So if Mairi could answer that first, thank you. Okay, here, Mairi is trying to reconnect. So instead, could I go to Kirsten to see if she could provide some response to that? What can we learn from the campaigns?
But then I wonder if you could repeat it. The sound was a bit difficult.
Yeah, Mairi, we'll leave you a little bit of break, just hopefully for your technology to settle. So the question for you, Kirsten, what are the most important elements to advance the campaigns for CRC incorporation that can be lessons for other countries?
From the campaign, you say?
Yes, that's what Tara put in. Like, yeah, what would actually make it help happen in other countries?
Wow. Well, I guess in general, mobilizing for the issue. I mean, having, of course, all the organizations that work for children, but also to try to make professionals understand that this is important, and maybe quite important actually, to make the legal community understand that it's not such a big risk, or it's not so dangerous somehow to incorporate the CRC. I think that I haven't really, as I said, heard any critical voices after it was incorporated from the law side. It's been used positively by many lawyers, and judges deal with it the way they can, and they haven't said that this is too difficult. They just have to deal with it, just like they have to with any other law that they have to interpret. So I think maybe to have the legal community on their side would be a good thing.
Kirsten, I found that so interesting, and I think it really educational for us in Scotland. Mairi, it looks like you're back on. Do you want to try again and see what you might add?
Okay. So if I was understanding that correctly, it was what are the success factors for campaigns to encourage governments to incorporate UNCRC? So I think in Scotland we have ministers who've made a very strong commitment to children and young people, and I described some of the detail of that, but I think they can point over the last few years to a number of quite significant changes that have been made in Scotland leading to this point. I think it's probably not without accident that we are taking somewhat of a different direction in Scotland than in some other parts of the UK, although of course there's much that we can learn from colleagues in Wales who have already pursued a slightly different form of bringing the UNCRC into their legal framework. In terms of success factors, a number of very active stakeholders who are very passionate about the agenda is clearly important. So folks who are raising this on a regular basis with ministers and bringing it to the front of their attention. But I think my sense is that the ministers we have, that falls on very fertile ground. They're very, very passionate about this and can see the potential, not just in relation to rights for children, but the whole panoply of international rights treaties, and recognising that is an opportunity to move our legal system into a much more strongly rights-respecting space. So both powerful advocates in civil society, but ministers who are sympathetic. And I guess a third success factor would be other examples. So countries that you can point to who have done this successfully. Professor Sandberg talked about how many of the fears were not realised in Norway, and I think that's really helpful and important for those who want to advocate for incorporation in other countries to be able to point to those examples. We've certainly found it useful in Scotland.
Thank you once again for such a thoughtful reply. My gosh, we're nearing the end of a discussion and there's many chats in there. I think that's maybe a sign of a good lecture, that people have so many things they want to contribute. I think I'll just end with one directed to Kirsten, and it's from Maria, and it seems a good one for ending the discussion. So the comment is, Kirsten, thank you very much. What advice would you give to the Scottish Government on the most important thing that they could do to ensure incorporation has an impact on children's experiences of their rights? A tough question, but we'd love to hear what you have to say, Kirsten.
Yeah, you are right. It's a tough question. I always find it difficult when I'm asked to point at one thing particularly. But I think children's participation is really, really crucial. And it's both on individual decisions and in collective decisions for children or a group of children. I think to put into legislation not only the CRC as such, but also to include the requirement to hear children in all sorts of legislation where children may have an interest in being heard. I think that is really something that would help children or would help implement the convention, and also the best interests. I think it's useful to have it there in the laws that the professionals actually use in their everyday life.
Thank you, Kirsten. What powerful statements for us to carry with us. So once again, thank you to everybody who's put forward questions and discussion points. We'll be noting what they are, and they're obviously setting big agendas for us into the future. But I think now, to keep to time, we're going to turn to Bruce. He's going to give us a final comment on really to take us forward from this lecture and beyond in terms of UNCRC incorporation. So Bruce, as you know, is the Commissioner for Children and Young People in Scotland, and how special to have him here to bring our conclusion to this lecture.
Brilliant. Thank you so much, Kay, and to all of the organisers for preparing this fantastic lecture, and the other speakers, and particularly to all of you who have joined. And I can see participants from across Scotland. Many of Scotland's champions for children's human rights are here, and also many friends from outside Scotland. Many of whom have been involved in the campaign over many years on incorporation, which even a few years ago probably seemed like quite a distant prospect, but now feels very much within our reach. And a special thank you, obviously, to Professor Sandberg. Thank you so much for being a champion for children's human rights. You've been an inspiration for a very long time, and today you've inspired us once more. I recall seeing you at, in Geneva at the last day of general discussion, talking with children from the Children's Parliament and young people from Scotland, and really demonstrating being a children's rights champion, but also speaking directly to our minister and to senior civil servants. And I think that that international input from experts, that collaboration is really important in terms of delivering incorporation in Scotland. The knowledge that the world is watching goes a long way in this country that sees itself as very progressive in children's rights terms. We know that the Convention on the Rights of the Child is special. There's a broad array of international treaties that impact on children's human rights, but the CRC bring together civil, political, economic, social and cultural rights into one place and puts children at the heart of it. And I'm glad, Professor Sandberg, that you talked about Norway and the example and being a dualist country and showing us how it can be done in terms of putting this convention into domestic law. You'd also talked about the early focus of your Human Rights Act being on the 3 central conventions. And interestingly, I thought, along with the UN and Council of Europe treaties primarily focused on civil and political rights, you'd also included the Covenant on Economic, Social and Cultural Rights there. Because I think one of the challenges that we have in Scotland is that, like in some other countries often described as being the Western world, we've focused our legal protections very much on civil and political rights, which is the wrong approach. And we've been much slower to address economic, social and cultural rights in our domestic legal framework. And I think there's still some lingering fear or concern around that. And so we have to be very clear that rights are indivisible, interdependent, interrelated, and that the jury is very good at understanding the interpretation of those types of rights. And so your focus on the importance of the text itself, this was something developed over a long period, building on the Universal Declaration of Human Rights, which proclaimed that childhood was entitled to special care and assistance, and building over decades of hard work up to a treaty which has been signed up to by every country in the world. And so there should be no fear of the Convention on the Rights of the Child. Rather, it should be seen as an important part of our legal framework. And recognizing that children don't have the same economic or political power, and they're entitled to additional protection through our law. I think it was also important that you started with the point that Article 4 and the expansion of the General Comment number 5 obliges government to change laws and policies to give full and direct implementation of the Convention on the Rights of the Child, and the strong direction from the committee that incorporation into domestic was necessary. I think it's also important to recognise, as you did, that there's an obligation to prioritise resources to protect, respect and fulfil children's rights, so that they have the things that they need to thrive. And in some of the public discussions and campaigning, we need to be clear that we're talking about things like good quality healthcare, education, nutritious food, and protection against violence. And these are things that are very much in the public consciousness at the moment with the responses to the pandemic and the restrictions we're all under at the moment. I've seen a really welcome change over recent years in terms of framing things like poverty as human rights issues, the growing acknowledgement of the human rights of children and prisoners. And I see that Nancy had framed a question around that. And also the development of the new general comment on child justice, which I think strongly on the work already done, including by the Council of Europe's guidelines on child-friendly justice. And so we have a framework that I think that there is public support for, and we need to be much bolder in harnessing that support, as you have done in Norway. And your comments also on the budget implications, in that we know that human rights budgeting actually leads to better results and is cost effective in the long term. There was some powerful work done there in the context of the recent care review in Scotland on human and economic costings. And I think that we need to develop that side of the argument much more effectively, that rather than being something that costs additional money, a rights-based approach to budgeting and incorporation of the CRC will lead us to make better decisions involving children and young people, which will not only make life better for children and young people and better for those that work with them, but it makes economic sense as well. I thought it was also really important that we focused on children's participation, not just in those things that are labelled as children's issues, but on all issues that impact them, which is everything. And so the growing acknowledgement that we need children involved in planning and justice, and that decision makers need to adjust the way that decisions are made to include children's experience and voices. It's very welcome that children and young people have been annually attending Cabinet, but it needs to go much further than that and embed children's participation in all aspects of our decision making, not just children's issues. But we can see the power of their involvement. The young advisors for my office have been very vocal throughout COVID-19 and the government's responses to that. And so we can see the real power of children's voices. I think your comment on the need for distinct complaints mechanisms is a very important aspect of that participation as well. The comments that you made in relation to the courts, I think, are really important, and this is a strong message that we all need to make to government, to Parliament, that we know from the countries that have incorporated the CRC, or those that have a legal framework for justiciability of economic, social, cultural rights, that courts generally take a very cautious approach. And while we're starting to see the beginning of a culture of strategic litigation here in Scotland, what we haven't seen is courts over-interpreting in any way rights. Rather, they take a very cautious and balanced approach. And the importance of bringing with us the local applicability, that all duty bearers should have a really good understanding of why incorporation will make things better for them as they undertake their obligations in relation to children. The general comments, I think are hugely important, and we need to do more work around understanding the power of the general comments. We've had a difficult relationship, I think, with the revised general comment on child justice, and I think that that's something that we could have handled a lot better. And I think that seeing the value of general comments and interpreting the convention, something that needs to be at the heart of how we implement the new law once incorporation takes place. But most importantly is this culture change that you spoke to, Professor Sandberg, in terms of that everyone kind of came on board with it. And while that doesn't happen overnight, that over time, this kind of gradual and hopefully exponential commitment to putting children and young people at the heart of all of our work. Also, I very much welcome your contribution, Mairi, today. I think that the commitment by the Deputy First Minister on behalf of the government to a maximalist approach to full and direct incorporation using the language of the convention, which is so important in terms of sticking to the text that was built up over many generations of people defending children's rights, and gives us real certainty in terms of what those rights mean, allows us to engage effectively with the international community and learn from comparator countries as well. Making it justiciable is hugely important. While courts aren't the best way of resolving rights issues, having that power we know leads to better decision making, and having it within the next year, as you said, Mairi, the next election due in May, and so we're very much looking forward to seeing the draft bill in the next couple of months and it being before the Parliament when it resumes in September this year, and I think that's really exciting. I did note, Mairi, that you said that Scotland's unique, and I thought that I think that is true. But as Anne Skelton from the UN Committee on the Rights of the Child said when giving evidence to the Scottish Parliament on the minimum age of criminal responsibility, every country thinks it's unique. This is something that the UN Committee hears from every country, and the limit on devolved competence will of course limit the our incorporation. But I warmly welcome the government's commitment to bring forward law that takes a maximalist approach. And so this is a hugely exciting time, and I'm really pleased that the work that the expert advisory group that was set up by Together and my office, and I know that some of the advisory group members are participating in this call, were able to play an important role in setting out the options for legislation and putting forward a proposal to government in 2018. And so I very much look forward to seeing the government's bill that builds on that and your own advisory group as well. I know we're short of time, but I think that some of the things that I'd also like us to go away with are this knowledge that we are working together on this. But Scotland is very good at making bold aspirational statements sometimes. We're often good at setting up reviews and making rules, but implementation, and particularly putting things into legislation, sometimes don't work as well. And so we need this commitment to continue across government, across parliament, at local authorities, and we need civil society to continue leading the way and standing up for children's rights. And we need to do further development on things like children's rights impact assessments, and many of you are aware of the work the Directorate is doing in relation to COVID-19, but also broader than that, the European Network of Ombudsmen for Children is focusing on impact assessments and building a new model and tools for that this year. So the use of impact assessments and budgetary approach to rights is really important. I'll finish maybe just by saying that we are in really exciting times, but we're also in challenging times in human rights terms. Global challenges like the rise of digital technology, climate change, prolonged conflict, mass migration are completely changing childhood. And adult decision makers sometimes struggle to develop legislative and policy responses that ensure children's rights and childhood as fulfilled in a time where things are different for children from the childhood that many decision makers remember. And so children's unique perspective about the world that we live in, which is different from how many of us grew up, needs to be at the heart of our solutions. And at a time where we're seeing regressions in human rights in other countries, even before COVID-19, and in Turkey on free speech, and Hungary undermining constitutional rights, Poland's attack on sexual and reproductive rights, youth justice derogations in Denmark, and right-wing populism growing across Europe, not even going anywhere near discussing what's happening on the other side of the Atlantic with the current government there, particularly the hostility towards the human rights of children. And we've got 9 countries in the Council of Europe that have put in derogations on ECHR in relation to COVID-19. So now time that we really need to demonstrate leadership. The world is watching what we're doing at the moment in terms of incorporation. And we've been really inspired by Norway, and thank you so much again, Kirsten, for your wonderful presentation today, and others. And so now is the time for leadership. It's time for Scotland to take the next step in putting the Convention on the Rights of the Child into our domestic law and making it meaningful for children and young people. Thanks.
And thank you, Bruce. You so coherently brought together the key points for us, and we'll be going away with those, I think, ringing in our ears and in our minds. So thank you so much for that, Bruce. And really, just to bring things to a close, as you might imagine, a huge amount of thanks from all the people in Moray House, from Rowena, the former head of school, who said, why don't we have an annual lecture on children's rights, and Richard, who made sure that it happened, to Alice and Pauline, Ruth and Mary Ann, who have helped out from the start, Herve Lacroix from Digital Services, who've been helping all of you with any problems with the technology, to the Observatory, who has been supporting the session in so many ways. We will make the recording available in due course. We welcome you to be part of the Observatory and help make all of this happen. The link is on the screen. And please do follow our work in Moray House if you're interested, from Twitter to the website to the blog. We'd love to be working with you if we are not already. And thank you to all of you who have attended and chatted and listened and contributed. We only hope that these discussions will continue. Our current situation here and around the world, as Bruce was reminding us, shows that human rights are actually central to our societies, and within that, children's human rights are a key part. Thank you very much.